I love a buttered biscuit.
Damn. How are you guys doing this evening? Man, oh man. Hope you're having a wonderful day. Oh boy. This week just keeps getting better and better and better. Hope you're not feeling the storms that are rolling through my neck of the woods. Hey Marie, how you doing? Good to see you. I'm glad you could make it by. AW, hey there. Christine, hello. Good to see all of you fine folks. Like I said, I hope you're having a wonderful afternoon, evening, morning, wherever it is that you might be. Oh, my favorite writer chick. Hello, Teresa Finn. Good to see you. Hope you're doing well. Man, oh man. Now, see, I don't have all of the documents for the Laura Owens thing, so I apologize, but I'm just not I'm not as tuned in as some people are. Happy Tuesday. It is a happy Tuesday. Soy Bang, good to see you. That's funny. That is so funny. Oh my gosh. Do we have an interesting one for you though? This is one that came in, and it's hard for me to get, like I said, it's hard for me to get some of these documents because, like I said, I'm not tuned in. So I have to go to secondary sources of stuff that I find off the interwebs, just like every other schlub. Hey, Terry Ham, good to see you. Good evening from the Maine. Yeah. Oh my. Oh my. Well, we'll go ahead and just pull this up. It is from the Justice for Clayton website thing here, and you may not be able to read it, but I can. So here we go. Here, I'll just do this. Maybe this will make it a little bit better. So there you go. You get to see my lovely face. Oh, so we have. This is the pursuant to Arizona Family LP petitioner Laura Owens or Laura submits the following notice of change of judge for cause and memorandum and affidavit in support thereof as explained below. There's clear and convincing demonstrating the judge currently assigned to this matter, the Honorable Julie Ann Matta, is biased, prejudiced, and is engaged in conduct which violates both Laura's right to due process. Hello, sir. Can I ask you a favor? Yes, you might be able to. How you doing? How you doing, Michigan? Good to see you, CJ. Can I ask you a favor? I don't know. Can you ask me a favor? I know very little. As explained below, there's clear and convincing evidence demonstrating the judge currently assigned. It's basically complaining about violated rules, the Arizona rules of judicial conduct. Performing an independent investigation into the facts of the case. Ooh. Considering and relying upon information posted on the internet about this case. Engaging in ex parte communication regarding the case with her father. You can discuss a case. Judge has that ability. Doesn't matter if she discusses a case or not. This conduct, while sufficient to warrant additional other relief, no, including but not limited to a new trial, establishes grounds to disqualify Judge Matta on the basis of bias and prejudice within the meaning of these particular parameters. For these reasons, Laura respectfully requests the family court presiding judge, Honorable Rhonda Fisk, review this matter and find that grounds exist to disqualify Judge Matta and promptly reassign this matter to a new judge. What kind of new judge is she wanting? I mean, Laura, all the facts were against you in this case. And see, even if you do bring this in front of another judge, all of your testimony from this prior judgment is going to be brought out in court. It's not going to look good for you. It's not going to look good for you. In the event that Judge Matta disputes the allegations set forth below, Laura requests that the family court presiding judge set this matter for an evidentiary hearing pursuant to the family law rule. And while doing so, the court approve the issuance of subpoenas and add test whatever to Judge Matta and her father, Mr. Howe. She is under no obligation to do that. Hey, Susan, how you doing? Good to see you. Laura feels like she can fool a male judge. Maybe there's always that possibility. I mean, it's insane. I mean, you have to understand that she's a little cuckoo for Cocoa Puffs. Just a little bit cuckoo for Cocoa Puffs. The facts of this matter are set forth in detail in the affidavit of counsel submitted herewith. In short, this case began simply as a paternity establishment action with one uncommon wrinkle. Doesn't matter. None of this matters at all. What he was before him. Hope you set up your microphones, use the right equipment for streaming. I would appreciate your assistance. Well, there's a lot. That's a lot to unpack. That really is. Yeah, setting up a microphone's pretty easy. It's you plug it in and you do some tests like on StreamYard and tweak it out from there. That's what I do. I mean, it's pretty straightforward. It depends on what kind of microphone you're getting, what kind of gear you're getting. I mean, each gear has its own ins and outs. Are you using a Stream Deck? Are you just getting a microphone, run it into a laptop? How powerful is your computer? Processing power, all that kind of stuff. It limits you. My suggestion is don't worry about that so much. Don't worry about the setup so much. Worry about being able to do the content, put it up, put it together. Hell, you can just do it on a laptop or on a phone. That's what a lot of people do is they'll just set up their phone, set it up in vertical. In that case, you can just go online and get a nice little, little stand for your, like a mount for your phone. Mounts right up on there, mounts up onto it, and you stream using just your phone. Pretty easy. I mean, it's, just a little, just a little crazy. Yeah, she is just a little crazy. Did you see if she wore a waist cincher in court? Oh, well, that wouldn't surprise me, but still, I mean, she's rail thin. She's like Skeletor thin. Not looking too healthy. Yeah, this doesn't matter what season he was on of The Bachelor. It doesn't matter. Laura claims she had a one-night encounter with Clayton in Scottsdale in May 20th of 2023, and she learned she was pregnant. Now see, she's changed what she said. Laura claims she tested positive for pregnancy on 5 different separate occasions. Yeah, would those be separate occasions spanned out over a period of a week or two? No, those were 5 separate occasions within like 3 or 4 days. Before this case was filed on May 31st, June 1st, June 19th, June 25th, and August 1st. Oh, that's whenever she's saying she did her testing. So she did one on May, another one the next day, another one on the 19th, another one on July 25th, and another one on August 1st. First test taken on 31st was an at-home type test. Wait, that's not 11 days after. So 20th. Okay, I guess it was. The first test was an at-home type test, and it was positive. Okay, so she went to a Banner urgent care for professional test. Another pee on a stick. See, none of these matter. She liked eating lollipops. Yeah, she loved sucking down the lollipops. Mo Raid, woohoo! Hello, Mo Raiders. Good to see all of you. Glad you could make it. Really, that's awesome. Oh. So after Laura informed Clayton of these tests on June 19th of 2023, June 19th. Okay. June 19th. So she did one on 2 days. So blah, blah, blah. It just goes through whenever she took her pregnancy tests. And none of these were blood tests. These were all just pee on a stick tests. Welcome to the crazy shizzy. Oh, yeah, it's crazy, all right. Yeah, so she just sounds to me like she's doing a bunch of crying after learning she was no longer preggers, blah, blah, blah. Laura filed nothing further in this case. That's not how you end a case. Does not see. Here's the thing with pro se, and they and we'll get into this a little bit later. Here's the thing. Welcome, Susan Stevenson. Good to see you. Glad you could make it. It seems to me that she claims that while the matter was pending, she had a blood test done on October 16th of 2023. See, now she's changed. It seems to me like she's changing up all of her story right here. Mom doc where it was confirmed. Okay. Confirmed she was no longer pregnant. Oh. Suggested pregnancy were not viable. Okay. So May, June, July, August, September, October. That's 5 months later. Oh, 6 months later. So she's saying May, June, July, August. May, June, July, August. No, it's 3 months later. I'm sorry. And what was I thinking? August, September, October. So in October 2016, she was still pregnant, which was okay. That's weird. About a month later, on November 14th, she was seen by another OB. See, she's leaving out a lot of stuff in what she's pleading here. After learning she was no longer pregnant, but she says that she already knew this because she supposedly found some sort of fleshy thing in the whatever. And could she find a partner? I don't know. Yeah, tap that like button. Tap it, rub it, massage it. So she's getting all pissy here. That's what it sounds to me like. She's just a little bit aggravated. She's changing the facts of what was proven in court. And so none of this matters. All of this right here, confusingly, okay, well, let's see. Shortly before the case was due to be dismissed for inactivity, he retained counsel. No, because that is not true. This right here, she's saying after learning she was no longer pregnant, she says she filed nothing further in this case. That's not how you close a case. That's not how you end a case. Right there is absolutely wrong. That is not how to end a case. You have to file for a dismissal of the case, or that you're dropping charges, or dismissal with prejudice, or dismissal, finding no charges, anything. And she, of all people, should know this because she's done how many court cases up to this point? On C, she can turn around and plead, well, I never knew. Doesn't matter. Pro se is held to the same responsibility that any attorney is. Just because, pleading idiocy is not an excuse. It won't get you out of jail. Won't get you out of a civil case. It would be like this. If I sued my next door neighbor and said, hey, next door neighbor, I'm gonna take you to court and I'm gonna sue you. And they have to go through a bunch of crap, a bunch of hoops. They have to hire an attorney because they're just like, I have no idea what I'm doing with this, and it's going to be smarter for me to hire an attorney. I don't know where this is going to end up, but I hire, they hire an attorney. I don't ever want to have to sue my neighbor, but it could happen. And they say, listen, I'm going to go hire an attorney. And then I don't do jack squat. I just basically do nothing. They're still out the money of an attorney. They're still out the money of whatever court filings they had to file. That can be in the thousands of dollars. And especially if they've gone through all of the rigmarole in the process of this and hearing this case, taking them to court to get a restraining order and all this other crap that she was pulling. if they're doing this kind of crap, well, geez, what do you think is going to happen? I want to make sure that I go after this. Calling your rump lump butt baby. Rump lump butt baby. I don't know. That sounds a little weird. I mean, if the booty play is your thing, that's okay. It is saddening to me that she thinks that she can just do this. And I mean, I'm not an attorney, but I know better than this crap. Good Lord Almighty. You don't file a suit without filing a dismissal. And then it has to be something that both parties agree on, which I'm sure the attorney is going to go, yeah, well, I'll tell you what, you pay the attorney's fees and we can drop this. I don't think she would have gone for it. Mm-hmm. They have other medical issues or a history of miscarriage. They should also seek a specialist opinion. Well, of course, she's not going to seek one of those. Why would she seek a specialist opinion? She is, she's a scam artist. That's all this is. It's a scam. And she got called out on her scam. She got caught. And instead of backing down, she doubled down. All right, well, if that's the route you got to take. That's the route you got to take. This is why it doesn't pay to be a Karen. When I act a fool, you'll get treated like a fool. Pity the fool. So it goes on to say that shortly before the case was be dismissed for inactivity, that's not how it works. Clayton retained counsel. Good man, smart man, who appeared in this matter for the first time on December 12, 2023. Mr. Woodnick immediately filed several pleadings, including a motion to amend Clayton's answer to the petition, which he should have done, and a motion for Rule 26 sanctions filed on January 2nd, 2023, as he should have. Notably, Mr. Woodnick filed these pleadings without making any attempt to meet and confer with Laura. It is not required that he meet and confer with her. It is not required, as far as I know, and like I said, I'm not an attorney, so I could be wrong. He filed these motions to make sure that this was taken care of, because it's saying that it says required by Family Law Rule 9C. Well, I wonder what Family Rule Law 9C is. We'll just look it up. Arizona Family Law Rule 9C. Law Rule 9C. 9. Let's see what that is. Make sure I get this right because my typing is bad. Let's see. All right. Let's see. What exactly does it say? Family Rule 9C says good faith consultation certificate. Generally with these rules, I'll just share this tab for you guys instead so you can see. And this was effective January 1st, 2023. It says for C, what should it be? DC. See, good faith consultation certificate. Okay, the certificate must demonstrate that a party has made good faith attempt to resolve the issue. The consultation or attempted consultation required by this rule must be in person, by telephone, or not merely by letter or email. Well, and there is no domestic violence. There's a current court order prohibiting contact between the parties. History of domestic violence. Well, if I'm not mistaken, there was that right there. And that's they're not required to personally meet or contact each other if any of this be alleged domestic violence was self-represented. None of those matter. This is completely different. Why is she quoting this? So this means nothing. I don't understand. I don't understand what she's going. Now, she was talking about appearance. Required counsel may appear as attorney of record by filing a document that identifies the counsel as record of party, right? It says the counsel may not file anything or any action on behalf of a party in open court without appearing as attorney of record, which he did. Duties: once the counsel appeared as attorney of record in action, except pursuant Rule 9E, counsel will continue as attorney of record before and after judgment until the time the final appeal is passed, the judgment becomes appeal or feel, and blah, 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 blah. Substitution, withdrawal, doesn't matter. Limited scope of representation, scope, and may limited scope involved in family court. Limited scope. Yeah, he's misquoting the law altogether. And it's saying without ever providing written notice to Laura of her right to amend or withdraw her petition is required by Family Rule Law 26C. So what is this one? This is 9. Well, let's go to table of contents and we'll look at Rule 29C. There is no 29C. There's 22. Let's see. That's weird. All right, we'll just look and see rules of family law procedure. Part, let's see, 10. Yeah, there is no 29C. Well, that's weird. Not seeing it. Let me see. Family Rule Law 29C. Arizona Family Rule Law. Family Law Rule. Law Rule 26C. 26C. 26 sub C. Okay. And it has nothing to do with anything. Okay. All right. Let's see what it says. Rule 26, family law practice. All right. Well, let's see. And they're saying C2. Okay. ABC. C2. Where is it? C2. That's B. C2. Okay. C2 and subs and B. Okay. Like C. So what it says, this is generally, if a pleading motion or other document is signed in violation of this rule, because you have to read the portion of it that's talking about consultation. Before filing a motion for sanctions under this rule, the moving party must attempt to resolve the matter by good faith consultation as provided by Rule 9C, and if the matter is not satisfactorily resolved by consultation, provided the opposing party with written notice of specific conduct that allegedly violates the section, which they did. If the opposing party does not withdraw or appropriately collect the alleged violation within the 10 days after the written notice is served, the moving party may file a motion under subpart C31. So this is completely different. So they're trying to change the law, providing written notice to her of her right to amend. No, they don't have to. If the matter is not, all that they have to do under this rule before filing a motion for sanctions under this rule, the moving party must attempt to resolve the matter by good faith consultation as provided in Rule C. And if it's not satisfactorily resolved by consultation, providing the opposing party with written notice of the specific conduct that allegedly violates the section. Well, right there, whenever he filed it in December, the motion for Rule 26 sanctions was filed on January 2nd. The answer to the petition that was amended was filed on December 12th, 2023. So December all the way to January 2nd, and it's under no obligation because she would have been notified. She would have been noticed that she was in violation of it, and she had her opportunity to change it. I don't see what the problem is here. She just didn't do it. Shortly thereafter, she retained counsel, who appeared on December 22nd. So he filed on December 12th. She retained counsel on the 22nd. So about the time that she would have received notice, and they filed a motion to dismiss with prejudice. And then days later, Ms. Lindvall withdrew from the matter with Laura's consent. And on January 2nd, 2024, that was the day that he filed the motion to rule 26 sanctions. Confusingly, I don't know how it's confusing about it. Confusingly, on January 25th, 2024, Judge Mattis issued an order granting Laura's motion to dismiss. Okay. In that ruling, the court indicated petitioner advises she is no longer pregnant and has filed a motion to dismiss. So did she? While the court will grant the motion, the issue of sanctions and attorney's fees remain. Judge Mattis then set an evidentiary hearing for those issues on June 10th, 2024. Okay. So there you go. This came out one day before Clayton's attorney fee statement. Yeah, exactly. It's crazy. He remains from the hurricane here in Michigan. Hey, didn't know you were near the ocean. Oh, you just talk about the wind? Okay. Well, that happens. So it doesn't matter. So the undersigned was first retained to represent Laura on March 25th, 2024. So she had from January, February, March. She had all the way up until March 2024. She had 3 months that she waited to get an attorney. After appearing in this case, undersigned counsel quickly discovered that Mr. Woodnick filed the Rule 26 motion for sanctions, among other pleadings, without first consulting with Laura or counsel. Doesn't need to. Doesn't need to. Hey, Tammy, good to see you. Hey, Bad Duck, good to see you. See, that's the thing. He doesn't have to meet with her. All he has to do is file it. That is enough notice, and then she can amend her notice. It's not her fault that she's an idiot. She just thought she wanted to be smooth and slick about it, because it seems to me every little thing that she's been doing has been to obfuscate all of her responsibilities. Well, that didn't work out well for her. And then, of course, 10-day written warning required by providing written notice to Laura of her right to withdraw her petition as required by family law. Okay. So if I'm seeing this correct, if you're given notice, and this is the thing, you're given notice. What happens is if I file something, it sends you a notice. It serves you. You're served with a notice of that. More than likely, she has an email address attached to this, so she would receive notice via email of whatever was filed in the case. That's how it works here in Georgia. I don't know about other states, but most likely he would have served her with these documents. Now, in serving her with those documents, that's enough notice that she is able to file. He doesn't have to consult her. He is not her attorney. She can go pound dirt. She can do whatever the hell she wants to. But if she doesn't file anything, that's on her. Just had crap weather in the UK. Ooh, that sucks for you. Jesus, this woman is ignorant. After counsel discussed these problems and despite initially refusing to do so, on April 3rd, Mr. Woodnick filed a motion to withdraw his Rule 26 motion for sanctions. Unfortunately, that request was not timely ruled on by the court, resulting in the undersigned filing a motion for judgment. Well, and let's see. She retained a March and April. You had 30 days, and you had less than 30 days. You had less than a month. You had a few days to do it, but you should have done that immediately. Just because your attorney sucks at being an attorney doesn't mean that they can't move on. The delay tactics are just a means to an end. Oh my God. These people are idiots. Just silly person. Let me see if I can pull up those documents. Documents. Here we go. Laura. Uh-huh. Okay, so they're saying this was on January 25th, 2024. January 2024. That's February, March, February 2024. Yeah. Okay. That's weird. So got 10, 12, 12, 8. There we go. That's what I was looking for. No, instead, she decided to write a whole bunch of, and she's writing freaking letters. What an idiot. God, this woman is about as smart as a turd. My God. Go continue on with this. So she's stupid. She's just completely stupid. The rain is warmer. Like warm rain. Have you ever seen the rain? Clayton filed a pro se response denying paternity after Laura informed. Okay. That was an older one. Here we go. Unfortunately, that request was not timely ruled on by the court, resulting in the undersigned filing a motion for judgment on the pleadings as to the issue of sanctions on May 10th. And that was also denied. Why was it denied? Well, continue on here. On May 29th, and this is just a few pages later, here we go. On May 29th, the minute order was issued explaining to the court had intended to grant Clayton's request to withdraw his motions for sanctions, but due to a clerical error, the acceptance was not remitted to the parties. Doesn't matter. On June 17th, 2024, filed June 18th, Judge Mattis issued an order finding in favor of Clayton as it doesn't matter. Okay, Judge Mattis issued an order finding in favor of Clayton as to substantially all issues in the case. Okay, and awarding attorney's fees in an amount to be determined by later application. Post-trial order was purported to find Laura lied about being pregnant in this case, as well as two other matters. That's not what it said. That right there is not what it said. And we can read that again by the judge. What the judge said is that although the tests show her to be pregnant, she never completed the portion of it to show irrefutable proof that she was pregnant. That's what the judge said. Okay? Just peeing on a stick isn't enough because you can get false positives. She never had anything done beyond that she proved in court. And on top of that, she lied to the judge multiple times. Now, it doesn't take much for a judge to go, listen, I know Planned Parenthood from my experience, and they're not open on Sundays. But that's not what happened. She decided to be a fool. And be a little pain in the butt in court. And she got called out on it. On June 20th, the post-trial order also purported to find Laura lied about being pregnant in this case. Yeah, well, that's not what she said, but she said that you weren't pregnant at the time that you filed the case, according to your testimony. And that she may have committed perjury in this case. Yes, or elsewhere. The order is not entirely clear because it doesn't have to be. Based on those findings, Judge Matter referred this matter to the Maricopa County Attorney's Office, as she should have done. She found criminal negligence in Laura's testimony. Things didn't quite add up. The attorney has the option, Maricopa Attorney's Office has the option to look at everything and could possibly come after her for perjury, which means that she's going to be serving some jail time. This is why you don't lie Sir. Since receiving the post-trial decisions, Laura has discovered evidence of extremely serious misconduct by Judge Matta, which is more than sufficient to remove her from this case for cause. Oh, really? What do you've got? Laura will also seek by a separate motion. Oh, she's got a new motion for a new trial and a complete reversal of all prior rulings issued in this case by Judge Matta due to her misconduct, in addition to other relief. Oh. Good evening, Sir Frank Otter. Good evening. I'm glad you could make it. Family Rules 6.1 provides grounds. Parties seeking a change of cause, blah, blah, blah. They're just going to go through legal standards. Don't care. Be used to that was the last part of that right there. If judges allowed to receive evidence which of necessity is to, let's see, account of the bias, prejudice, or interest the judge cannot obtain a fair or impartial trial is important. Does not contain any express time limits for seeking change of judge, but Arizona courts have read the statutes containing implicit limit. Party cannot ask disqualify judge under blah blah after a trial is begun. There you go. Explaining if a judge is allowed to receive evidence which of necessity is to be used and weighed in deciding the ultimate issues, it is too late to disqualify him on the ground of bias and prejudice. At the same time, it also noted requests to disqualify a judge made under authority, not ARS, blah, 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 are not subject to the same implicit restrictions as requests. Instead, Icasio explains request, blah, blah, blah. Change of right. Here, Family Law 6.1 does not contain the same waiver language. On the contrary, Rule 6.1 only requires the party seek a change of judge for cause within 20 days after discovering the bias for the request. And the rule expressly provides case evident events or actions taken before that discovery do not waive. Okay, I'm not seeing anything here. Just basically, there's saying the matter of law is explained. Okay, the grounds upon Mata shows her post-trial rulings filed June 18th. Rather, the judge, Mata, made findings based on an improper ex parte investigation. Oh, really? She conducted, which included reviewing information posted on the internet. Now, that right there would be incorrect. Wouldn't it? That would be incorrect because she's saying that there was an ex parte investigation. So you have to prove this. First of all, you have to prove that there was ex parte communication. Ex parte investigation. Huh. You have to prove that. Which reviewed information posted on the internet about this case. Until Judge Matta's post-trial ruling was issued on 18th, Laura did not know and could not possibly have known the judge's misconduct in this regard, which would be true if there was any misconduct. Although this single issue is sufficient to grant the relief to request, there is also evidence showing other misconduct, okay, including that she engaged in improper ex parte discussion of the facts of this case with her father. Okay. Harry Howe, in violation of not 2.9, the Arizona Code of Judicial, although Laura and undersigned counsel heard rumors about Mr. Howe appearing at the trial on June 10th. Okay. Doesn't matter. See, that's the other thing. You have to prove that there was ex parte communication with her father. Just because her father showed up, then you're going to say that there's ex parte communication? That's weird. Hey, Christine, how you doing? It makes no sense to me that she's claiming these things that without proof. First of all, you have to prove that she did any sort of ex parte communication with someone outside of her immediate realm. Just because she said hello to her father does not mean that she discussed the case. Do you have a recording of him discussing the case with her? Did you sit down with him and he admitted to this? Do you have any proof of this whatsoever? Because if not, then you're making wild allegations, and more than likely a judge is going to look at this and go, you're making up shit. Just because someone showed up in court, that does not mean that they were having this communication. That would just be like saying, well, she discussed this case with Clayton's buddies. Not true. Not true. Blood warnings. Excessive heavy downpours could get 40 to 60 milliliters overnight and ending Thursday sometime. Ooh, time to get out the canoe. Be safe. Okay, so it says that heard rumors about Mr. Howe. Those are just rumors. Rumors are lies. Howard appeared on the trial on June 10th. Specific details of exactly what occurred and proof of establishing these facts was not fully known. What was fully known? If you provided proof. For the reason this request is timely pursuant. No, it's not, because right here you've said in that short period of time you don't have any proof of this because it's just rumors. The details of the grounds for disqualification are set forth in this affidavit and blah, 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 because episodes of such brazen, blatant misconduct. Oh, brazen, blatant. So full of crap. That case, this is like a matter involved of Hamley Court proceeding in Terry. The assigned judge posted comments about the case on Facebook. What this judge did not. And also used the internet site Google to find information about a party's photography business. The judge also visited the website of a party and copied a poem from that party's website, which he recited at trial. But that's not what happened here. Upon discovering these facts, one of the parties moved to disqualify the judge, asked to vacate the judge's post-trial orders. One of the parties, yeah. Those requests were granted to their entirety. Completely different. This is also North Carolina Judicial Standards Commission. This is North Carolina, not Arizona. You have to set precedent. State. What I know, I could be an idiot. So don't rely on me. Conducting an independent ex parte online research about a party presently before the court and by having ex parte discussions about the case, the commission found that judges' actions were prejudicial to the administration of justice that brings a judicial office into disrepute. But that's not what happened here. Me having a discussion with my father that happened to show up in court if I were a judge does not constitute that I was discussing the case. They may have been there listening to the case, but you have to provide proof that we were even discussing the case or talking about it, which you have failed to do. Now, if you want to hold a judiciary hearing, I am sure that Judge Matta would be more than happy to show up in that particular hearing and would more than likely be happy to sit down and discuss with whoever is in that hearing what exactly occurred in court and call you a lying liar, piece of garbage crap one more time. Hey, D. Robertson, good to see you. Good to see you. Glad you could make it. I'm going to do something real quick. I am going to grab myself another alcoholic beverage because this one is getting spicy. Oh my. She is a silly child. And Dingus or Gringus or Gringo Ass or whatever his name is, he is grasping at straws because he knows that his client sucks. At least he's fighting for her diligently. You know, this is the kind of attorney that you, although he may be an idiot, this is the kind of attorney that you want to have on your side. You want to have an attorney that fights for you at every bit of their being as much as they possibly can. Okay, notwithstanding all their other powers and responsibilities, judges acting as fact finders in a bench trial are subject to exactly the same rule as jurors. A judge may never investigate the facts as a matter of independently and shall consider only the evidence presented, and the facts may properly be judicially noticed. Prohibition against a judge independently investigating the facts in a mere matter extends to information available to all mediums, including electronic. Well, so what do we have? And I would have to pull up the whole court thing again where it was discussed, but if I'm not mistaken, the lady that came up, talked about Planned Parenthood, said in the court that Planned Parenthood is not open on Sundays. That would have been evidence presented, and it would have been Gringus's or Gringas or Gringo Ass or whatever his name is to dispute that fact, which he never did. I guess I could always pull up that court case again and get to the point where that person is talking about it. But we'll do that a little bit later on. We still have time. And so we'll come back to that. What I'll do is I'll see if I can pull that up before we finish out tonight, because that her testimony was pretty important. If I'm not mistaken, the judge did ask her a few questions. So let's pull up the Clayton's expert witness. We'll pull them up and see if actually that's what happened in this particular case. Furthermore, although judicial blah 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 evidence only, possible sources information was independent investigation. Well, and see if you're relying on this. Well, you know what? I'll just go ahead and pull it up, because I am not going to sit here and argue something that I can't prove for sure. So we will just go to the actual video itself that I happen to have here, and we will pull up where is it? Let's see, we've got her here, and that's in them, and then they bring up this lady right here, and we'll go ahead and share this particular one with you, because this was her testimony.
Hey, Dr. Deans, are you able to hear me?
Yes, I can.
Okay, counsel?
Before we go on the clock, Dr. Deans, can you hear me? It's the voice of Greg Woodnick.
Yes, I can see you too.
Oh,
Counsel?
there you are. Thank you. All right, we're ready, Judge. Thank you.
Hold on 1 second. I want to make sure she can hear everybody. Counsel, will you do a test, please?
So this was
Hi,
her testimony.
Dr. Deans, good morning. Go lightning fast. Introduce yourself to the court.
Yep.
No objection.
E39's received.
You also did a report for us. It's Exhibit 41, which we'll pull up on the screen. Did you have an opportunity to review the medical records for Laura Owens?
Yes, the ones I was provided with.
Exhibit number 41. Did you know that was published online on a website?
Just to confirm, I'm looking at my report, and no, I did not know that was published on a website.
Did you give Miss Owens permission to publish your report on a website?
I did not.
Okay. Judge, I'm tendering Dr. Deans as an expert here. I have one voir dire question for her.
Okay.
Dr. Deans, hi, good morning. How many children have you delivered as a OBGYN?
Oh, that's all you got.
Probably too many to count, but I would say at least 3,000 at this point.
Okay, I stipulate to her expertise.
So stipulated.
All right. Basic question, Dr. Deans. I'm going to go fast here. Do you have concerns regarding the legitimacy of some of the records you reviewed?
I do.
If this court were to assume that the June 1st HCG test actually came from Laura, would that confirm pregnancy?
No.
What is the medical standard of care to confirm a pregnancy?
That would have to be either serial HCGs showing a trend over time,
Right
or a pregnancy test and
That's
or an
one.
ultrasound, or a physical exam that confirms an intrauterine pregnancy.
And we had none of that here, correct?
Correct.
All right, I'm showing you exhibit number 28. Are you aware
no
that
problem,
that's the
Katie.
ultrasound from Laura? Are you aware that was altered?
Yes, I am.
Laura claimed it was anonymous and from Planned Parenthood. Any thoughts about that?
Patients cannot be seen anonymously at Planned Parenthood. Planned Parenthood, having been a former medical director of Planned Parenthood, PPFA, which is our national guidelines, require identification at the time of a visit to confirm the identity of the patient. The patient can't be seen anonymously.
Thank you. Laura claims she was pregnant with twins. Anything you reviewed in any of the medical records confirmed that Laura was pregnant with twins?
No.
Laura claimed that the twins were boy and girl gender. Anything that you reviewed that confirms that?
No.
Do you recall reviewing the October 16th HCG test? I think it had a 100 or 3-digit HCG level on it.
I do.
Are you aware that there's actually 2 other versions of that exact same test in circulation?
I've heard that. I have not.
Yep.
If I told you there was another version with 1,000 times higher HCG level, would that cause you concern?
Can you guys hear that
Yes, it
at
would.
all?
Are there alternate causations for a positive HCG test as we have here?
Yes, sir.
Did you review I'm going to skip over the photos. Did you review Dr. Medshill's report?
I did.
You're aware that Laura
I want to make
first
sure you
claimed
guys
she
can
miscarried
hear
in
this.
September, October, and then the photos that are in the report indicate that it happened in the third week of July,
Hello,
correct?
Squid. How you doing?
Pursuant to Dr. Medshow's report, he concluded, do you agree with his conclusion?
Can you guys do me a favor and give me a thumbs up if you can hear this? Because it's not showing that I'm getting any sort of output here. So if I'm not getting output, I just want to make sure. Just give me a thumbs up if it works. I know it'll take a couple of seconds before you'll see this. So if you do, give me a thumbs up so that we can make sure that we hear this. You can hear it. Excellent. That's all I need. Thanks. I appreciate it. All right. Let me do this and we'll continue on.
That the data here warrants that Laura was 99% pregnant.
No, I do not agree with that assessment.
Do you agree with Dr. Medshow that the record confirms, this is from his report, a May 20th conception date?
Absolutely not. There's no data to confirm a conception date at this point that would require an ultrasound dating of a pregnancy.
There you go.
Professor Deans, thank you. Judge, I just moved to admit Exhibit 41 if I didn't already.
Any objection?
No objection.
41 received. Cross-examination when you're ready.
Dr. Deans, you reviewed records that showed that Laura had HCG in her blood October 16th, 2023. You familiar with those?
Yes.
Where did that HCG come from?
It could come from a variety of sources.
Okay. And your report mentioned some of those sources. I'm just going to ask about specific things. Exogenous injection. I'm assuming that's a fancy way of saying sticking yourself with a needle.
Correct. Exogenous would be an HCG source from outside of the body.
And do you have any information or have you seen any records that suggest that happened here?
I don't.
Okay. Heterophilic antibodies, which I did a little reading on that. Some sort of allergic response, it sounds like maybe.
So brave, so bold.
Correct. An autoimmune response can be triggered by exposure to animals and create positive tests.
Okay. But the fact that Laura tested negative for pregnancy November 14th would appear to be inconsistent with at least the heterophilic antibody theory. Would you agree with that?
It depends on the type of test. A urine pregnancy test might be positive, but a blood test could still be positive. It depends on the assessment and the level of HCG at the time of the test.
Okay. And I think Dr. Medchill said, and I think you also said that cancer can cause elevated HCG levels. That's a fact, right?
Correct.
And have you seen any records to suggest that Laura has cancer presently or that she did in 2023?
Not presently. No, I know there's a discussion of a prior history of ovarian cancer.
I understand that. But regarding 2023, if Laura had cancer in 2023 that caused false positive pregnancy tests between May and October, when the last one was.
No proof one way or the other.
How can you explain her testing negative in November?
I think it makes that less likely unless she had treatment in the meantime.
And another option that you wrote about in your report was something called familial HCG syndrome as being a way that someone could test positive, have HCG in their blood, not from pregnancy, correct?
Correct.
Do you know how rare that is?
Very rare.
I read that it was about 10 cases in the planet. Does that sound about right to you? And again, if Laura had familial HCG syndrome, that would explain some false positive tests in the middle of the year, but it wouldn't explain the negative at the end, would it?
That is correct.
Dr. Deans, in your report, you talked about objective evidence of pregnancy. On the first page in particular,
yes.
You said that the only objective evidence of pregnancy is a Banner urgent care serum quantitative HCG well, I think that's actually a misstatement. The October 16th wasn't at Banner, but there was a serum HCG, and you've referred to that as objective evidence of pregnancy. Is that true?
Yes.
Correct.
And in the absence of some other explanation, cancer, familial, horse tranquilizers, or whatever, in the absence of some other explanation, you would agree, and Dr. Medchill, I think, said, that HCG test from October 16th is objective evidence of pregnancy, right?
It is objective evidence, and one of the possibilities of that objective evidence is pregnancy.
Right. And if a woman is pregnant, regardless of how much or how little prenatal care she has, she's still pregnant, right?
If she's pregnant.
If they are pregnant, yes.
I mean, a woman could be pregnant and have no ultrasound until the day the baby comes out.
Yes, but that would require the woman to be pregnant. And she is yet to prove that she's pregnant. It is so good to see you, White Rabbit. And I'll probably be sending everybody over to you tonight. So I'm looking forward to your wonderful stream. Mm-hmm.
And she's still pregnant, right?
Yes, and the objective data would be the baby coming out of her body.
Right. And Dr. Deans, you worked, or your report and your resume indicated that you worked at Planned Parenthood for a while?
That's correct.
In that capacity, did you counsel women regarding terminating their pregnancies?
Correct.
And just for the record, I'm strongly pro-choice, strongly Planned Parenthood. If a woman was choosing or was thinking about choosing to terminate her pregnancy, why would she have prenatal care?
Oftentimes, patients care first to confirm their pregnancy before they make their decision about how to end it.
But in a lot of states...
I'm sorry to cut you off.
I'm out of time. Thank you very much. Thank you.
No redirect. Thank you, Professor Deans. We appreciate your help.
All right. Any
Thank you.
objection to the professor disconnecting?
No.
All right. Thank you, Dr. Deans. If you'd like to disconnect, you may. If you'd like to stay and listen, you absolutely may.
Thank you very much.
Welcome.
Time check, Judge.
I thought it was that doctor that whenever she was talking about working at Planned Parenthood, that she was saying that that they weren't open on Sundays. But I could be wrong. That might just be me reading into it. It does happen quite often. It is one of those weird things that I'm pretty sure that I heard something along those lines somewhere in this case. I'm trying to remember where I heard it. Okay, not there. Not there. Clayton. Let's see.
But at her, right before, what happened a day or two related to Exhibit 55, a day or two before your deposition? Quickly, for attorney's fees purposes, exhibit number, well, let me get in a few exhibits real quick.
Okay, no.
Okay, so counsel, what exhibit were you asking me about?
I should have emailed part of the time, but not all of it.
You can't really be held accountable for that. I understand. Anything else administrative?
No, thank you, Judge.
All right. So how this will work now at this point is,
Well, and it wasn't there. So I was wrong. I thought that judge had actually said whenever this had happened, and I was incorrect on that. So what it was is that the judge did was that it is a possibility that the judge just already knows this. Cancel that, and we're gonna close this right here because it's blaring in my face. I wasn't positive. I had to be sure, but I was thinking that that's where I heard that from. We're gonna try it and set it up tonight. Nice, very nice. But there's also a possibility that the judge just knows it from her own experience that Planned Parenthood isn't open on Sundays nationwide. Not that they would even have to do a search on it. It's just a known fact that they're not open on Sundays. But it wasn't something that was brought forward in the case. But there's also just knowledge of things as they are. So, like I said, they have to prove that she did some sort of search, which they didn't do. Yeah, you thought the same thing. No, and that's why I wanted to prove if I was right or not, because I couldn't remember if I thought that she had asked the judge asked that particular witness some questions, but she did not. This information independent investigation of the facts, but if she already knows it's not independent, does allow a judge to base findings on facts which may properly be judicially noticed. The business hours of Planned Parenthood locations of 2023 is not a fact subject to judicial notice. But it wouldn't matter. It wouldn't matter if she knows or not. In this case, just that one little snippet's not going to change the rest of it. Does that make sense? So just because the judge stated one thing does not mean that the rest of the case is faulty. Again, because such blatant misconduct is rare, it's not blatant, and you have to prove that there was misconduct. There's no directly controlling comparable Arizona precedent on this issue. Of course, there's not. However, courts in other states have consistently agreed this type of judicial misconduct is per se unlawful and entitles the movant to automatically relief regardless of whether the error was harmless. Doesn't matter. Where the judge asked the law clerk to perform independent investigation into the facts of the case and explaining under our system of laws, the judge is not an investigator. The investigative functions belongs to the parties and their agents. Laudable goals and lofty purposes cannot be attained when the cost of the loss, or even if the appearance of loss of judicial impartiality, they're just bitching and moaning right here. It was a law clerk's duty as much as that of the trial judge to avoid any contacts outside the record that might affect the outcome of the litigation, and further explain the law clerk's private view of an accident in litigation was prohibited, blah, blah, blah. Congrats, Squid. I'm so happy that you're getting a new computer. That's a beautiful thing. Those are always fun to get set up. And let's see. Bitch, moan. Based on this authority, Judge Matta must be disqualified on the basis of bias and prejudice reflecting her gross misconduct. These facts demonstrate that Judge Matta did exactly what the rules expressly prohibit. No, she didn't, because you have to You have to prove that this is true, which they have not done. Other evidence supports a finding of judicial bias. The law is clear. A single instance of misconduct by a trial judge is sufficient to establish bias and require disqualification of the judge. But the evidence of bias and misconduct is not limited to just the Planned Parenthood is closed on Sunday issue. Rather, an explanation and the affidavit of counsel submitted herewith. Another separate issue also established Judge Mata's bias. There's evidence showing the judge shared information about this case with her father. Oh, really? What does it show? What is the evidence? It says that appeared as a trial as a spectator. He later socialized with Clayton's supporters. Okay, telling them comically, "I'm just here for the shit show." Sure. Okay. That's his opinion. I think a lot of people were there for the shit show. And would you have known that it was her father? Probably not. It's difficult to imagine more disrespectful, disreputable, and disgraceful act for any judge to commit than inviting her father to attend a high-profile trial. A high-profile, sweetheart, do not flatter yourself. It was not that high profile. You are thinking of yourself as being something more than you actually are. You're not as high profile as you are. You may be something, but you're not as high profile as you are. Let's put it this way. If I was to have to go to court, how many people do you think would really give two craps about it? I mean, you guys might, but that'd be about it. All 29 of you people that have hit that like button, I'm sure you reached over and you tapped it. You would care. I doubt it. I doubt it. You would be just like, "Oh, Shissy had to get a card. Hooray. Is he live streaming it? Nah, don't really care." You'd be just like, whatever. Oh, God, Lord Almighty. It's difficult to imagine more disrespectful, blah, blah, blah. Warrant a mistrial. Oh, no, it won't. A retrial before a different unbiased judge. The shameful conduct. Shameful. Not only violated Laura's rights, it raises serious questions regarding Judge Mata's fitness as a judge of the Superior Court. Oh, any reasonable, objective observer in Laura's position would be justified in wondering, was my case legal? No, your case was absolute shite show. Fairly decided based on the evidence, it was Judge Mata simply trying to impress her father. Look at me, Daddy. I'm a real judge now. Oh, Jesus, you did not write this in a pleading. Oh, my God. You did not write this in a pleading. Oh, jeez Louise. Oh. Tell me, this idiot did not write this in a pleading. Are you dead serious? What kind of dumbass lawyer is this guy? What kind of dumbass is this guy right here that he actually wrote that in a pleading? Whew. No, you don't want to be doing that. No. Oh God, no. Don't, no, that would be bad. Assuming the published allegations of Judge Mata are true, they're not. As documented on video by Clayton's own followers, they're not. This proves Judge Mata separately violated Rule 2.9 of the Code of Judicial Conduct, and Judge Mata's blatant pervasive disregard for her ethical duties and her disrespect for Laura's fundamental rights helps explain the judge's numerous and otherwise hereto inexplicable adverse rulings during this action. No. It was because you didn't do things properly, because you wrote shit like, "Look, Daddy, I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee hee hee." Whenever you write that shit in a pleading, it does not give you a whole bunch of goodwill from the court. Holy shit. The fact that the circumstances described above make this case one of the exceedingly rare exceptions because you're making crap up, in which this trial judge manifested clear prejudice and or bias early in the proceedings. No, because you did things improperly in the forms of multiple unexplained adverse rulings because you didn't do things properly because maybe you're an idiot. I mean, here's the thing. I mean, and I'll say this like straight up. My wife filed an appeal improperly, and that appeal was denied, and basically kicked that thing back down to the lower court's ruling. Like basically, she couldn't appeal it after that because she filed the appeal improperly, and she went, "Damn, oops, that's the way it goes." There's nothing you can do about it. At this point, you're just like, it's done. It's over with. You know, it's not an uncommon mistake, and probably the same mistake that the opposing party made also, because they didn't like the ruling of what was filed or the outcome. That's how it goes, and you have to sort of take your licks and deal with it. And it sounds to me like Gregarious or whatever, Gregarious or Gangrenous or whatever his name is, he's just not, he's just salty because he didn't file shit properly. But unlike 99.9% of cases, here there is clear extrajudicial evidence. No, you have provided none evidence showing the true reason for those rulings was, in fact, a hostile feeling of spirit of ill will or undue friendship or favoritism. You have yet to prove that. Of the litigants' evidence of Judge Mata's misconduct vis-a-vis her father, discovered only after the trial, but you've done nothing to provide that or prove it. You know, this is going to get thrown out so damn fast. Whenever they read this, they're going to go, yeah, that ain't happening. Supports a finding the bias which does arise from extrajudicial source and not merely the adverse rulings themselves, and disqualification may be separately supported on this basis. For the reasons stated above, Laura respectfully requests the family court presiding judge, Honorable Rhonda Fisk, review this matter and find that grounds exist to disqualify Judge Mata and to promptly reassign this to a new judge. In addition, given the clarity of the evidence and the severity of the misconduct and harm caused to the judiciary as a result, Laura further requests that the presiding judge refer this matter to the Arizona Commission on Judicial Conduct for further investigation and action as may be appropriate. Well, tough shite. That's all I'm saying. It's tough shite. You are going to have good luck proving this, which I don't see it happening. So that right there was Laura's saltiest filing after what really wasn't hers. It was more of Green Goat or Green Gots or whatever his name is. I mean, he matters not a whole lot to me. So just say he doesn't matter a whole lot to me. I mean, what do? You just go, oh, I'll shake my head and nod like stupidly, because that's about what it is. It's the most ignorant crap that I've possibly read from an attorney, and I've read some really crappy stuff from attorneys that like have no case, and well, they obviously don't have a good case here. Again, jeez, but we do have the Laura's little bitch and moan session. It is so amazing that she just cannot let crap go, because, well, she's salty, and all she had to do was just swallow. Oh, actually, I think I wrote this. Yeah, I already read this one. This one was silly and stupid. All right, well, we're done with Laura Owens for tonight. Isn't that amazing how fast we can go through her bullshit? Judge Mata, please sue Green Goats for defamation. No, there's no point in that. See, here's the thing, because Green Toe will be in front of her again at some point in time, and she'll treat him with the same respect that she treated him the first go around. Like I said, Green Toes is still an attorney. He is fighting vigorously for his client, and judges don't take this in as an offense. I mean, they look at it and they go, yeah, that was a stupid thing to say, but generally they're just going to go, yeah, it's not worth my time or energy and to respond to it. You're going to get this on a regular basis from attorneys that are fighting for their clients. Doesn't mean anything. Usually the judges look at it and go, yeah, that's it. It's not going to change. It's not going to change my ruling. You know, it's like he looks like a small child, petulant and angry, and can't do anything. Incompetent, incapable, just so horrible that you can't get enough. You just can't get enough of it. Oh my. Laura will never swallow pride. Well, she swallowed everything else. I got stuck on the way down. Oh my gosh. So what do we have here? Well, we've got more of this. More of the Sarah Boone, her wonderful letter. Oh, it's so glorious. So joyful. Oh, woe is me. I think we read part of this the other day. There we go. Make that bigger and we get rid of that right there. And that way you can read along with me. Honorable Judge Kranick, 425 North Orange Avenue, Orlando, Florida, 32801. Sarah Boone with this case number. Your Honor, I was made known to me by an officer here at the Orange County Corrections Department that my attorney, Patricia A. Cashman, has submitted her motion to withdraw on 6/11/24, which now explains why she has not contacted me nor answered any call. Little bitch. Why hasn't anyone sent me a copy so I know? To confirm my exclusion in my care, especially by Attorney Cashman, and as stated in all my letters previously written, I was not included, and am finding out weeks later. Judge Kranick, I'm trying to receive, please, a copy of her withdrawal to better understand her reasons for undisclosed departure from my new case. No attempt was made on her part to solve or remedy in some type of discussion professionally beforehand. Therefore, I'm having to include you for this request as I did with my other most recent letter, Judge. No computers in jail? No, there is no computers in jail. More than likely, she has to handwrite these, and then she has to file those with the court. The court basically files them, and that's it. Then we get to read them because the judge does not give two shits. Judge is just like, you can write these letters, but this is ex parte communication, so it basically is filed. Please understand. I am trying to understand. With her attempted withdrawal, deep withdrawal, my very legitimate concerns now is not having all my case contents returned to me as with a host of my prior attorneys. To date, many of my evidentiary case items cannot be located after my numerous requests to the attorney on my case at the time and to Attorney Cashman. Oh, woe is me. No one knows where my case items are, who has what, or who cares to research and return now that I am no longer under their representation. Shrugged shoulders at avoidance and lies of where anything may be is all I have received when requesting from former unwilling, disingenuous attorneys. These are my case documents. Attorney Cashman stated to me more than once, for me asking repeatedly about that she had reviewed all of my discovery, which I was withheld from reviewing, also, so I do not even know all she had specifically and completely and what was available to me. Your Honor, how can I ensure, please, the return of all my case contents from my attorney, Cashman? When may I finally review my discovery and the contents she has in my case so I know what is still missing or lost? Pardon me for having to utilize your invaluable time to ask to receive my invaluable case item. Please understand. I am trying to understand how and when I can fully, rightfully defend myself. Due process is overdue. I thank you in advance for my inclusion to also receive a copy of Attorney Cashman's withdrawal notice and for helping in the ensurety of all my case contents to be returned successfully for my historical review from the Cashman. All other former attorneys also, please give me a former attorney's information. Judge Granick, will you never understand my gratitude for listening to me, giving me opportunity to finally be heard, and your apparent caring judicial manner? Can I give you a back rub later? Thank you immeasurably. I await the next appropriate step in moving forward. However, and with whomever. Because isn't that how it works? I'm not going to get a new case attorney that's going to handle this for me now. Sincerely, Sarah Boone. For the inclusion futuristically unto an insured receipt of all correspondence to me in my case, my address is as follows. I am including Attorney Patricia A. Cashman with a copy of my letter, mailing it to her at her address, or attorney's address, because that is what I do. I cannot leave it alone. I must touch it. It is like a sore. I must scrape upon it until it bleeds profusely, usually from the anus. What can I do to get rid of this? Oh. And of course, the judge did have a response, and the response to that was just to basically say, hey, Biatch, you screwed up. That's basically what the judge said. Just like, well, you got your order. The cause came before the court on June 28th, 2024, on defense counsel Patricia A. Cashman, Esquire, motion to withdraw as counsel filed June 11th, 2024. The court having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman, Esquire, having considered the testimony offered by the defendant, Sarah Boone, and having considered the positions offered by counsel for state, hereby finds on March 23rd, 2020, by of information the defendant was charged with murder, blah, 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 and procedural history. We go down through all of that stuff, and we can just keep on scrolling because it doesn't really get much better than that. They're just basically saying that this bitch done gone through so many people that, she been run through. Just saying. If this was a gangbang, she would have had one hell of a time. She might have set a world record. But we get down to the meat and the bones of all of this, and this is where it is. Forfeiture of right to counsel. This is the important part. A defendant in a criminal case can forfeit right to appointed counsel. Forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel. That results in the defendant being required to represent themselves even though he has not waived counsel and may still want legal representation. Forfeiture is a judicial response that adapts the course of legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. As set forth above, defendants, I'm not even going to try to pronounce that word because I just can't read properly. To the attorneys who were not conflicted out, which was about 4 of those, there's lots of antagonism, otherwise she's being a bitch, hostility, being a bitch, and attacks, being a mega bitch, on the professionalism of Padilla. Notably, over a year after the fact, see the footnote 9 above, of Crazy Bitch, of Bankowitz, and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of them, their attorneys are required to withdraw because, well, they would have been conflicted out. It has become apparent that the court of defendant will not permit herself to be represented by anyone. Talk about a Karen. Additionally, that their withdrawal, there are different attorneys, 7 of which were court appointed, leads determination defendant had forfeited her right to counsel. See what's going on here. Proceeded, other grounds. Under Florida law, the facts to bar amount of fine and forfeiture of the right to counsel. See the below. As the court finds, defendant has forfeited the right to court-appointed counsel. Under Florida law, there's no obligation to conduct a further hearing or otherwise warn the defendants of the dangers of proceeding pro se because, well, bitch already done known because we told her multiple times you don't want to be representing yourself, but if it comes down to that and you keep acting a fool, that's what you are going to end up doing. That's what she is doing now. So she has basically forfeited this and she has done a waiver by the conduct. Court can find a waiver by the conduct to the right of counsel. Waiver by conduct requires the defendant be warned twice about the consequences of his or her conduct, including risks of proceeding a pro se, which they had done. And on February 9th, 2024, defendant was twice advised that another court-appointed attorney may not be provided. And on May 10th, 2022, defendant was again advised of the dangers of self-representation. And on February 9th, 2024, defendant was advised at that point in time the dangers of self-representation. And also, as of February 9th, 2024, the instant case has been continued 16 times. As of June 26, 2024, this case has been pending for 4 years, 3 months, and 5 days from the date of filing of the information, March 23rd, 2020. That's before the lockdowns really took place. Could you imagine? This case has been going on since just a little bit after the lockdowns. Actions speak louder than words. Well, and stuffing a man in a suitcase says worlds of difference. Although defendant's words seem to reveal a desire to go to trial, however, as set forth here in her actions and inability to work with court-appointed counsel are repeated over and over. Usually around the full moon, she starts to howl and scratch at herself, allowing defendant, her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was brought forth by the defendant's attention on May 10th of 2022, 2 years ago. Defendant complains that Bankowitz and Hobbs and 2 court-appointed attorneys failed to meet and communicate when that their defendant is provided court-appointed counsel who will meet and communicate. Cashman, the ways and means of meeting and communicating are unacceptable to the defendant, of course. Under Florida law, the facts at bar amount to binding waiver of the right to counsel. See Jackson v. State, blah, 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 blah. But she was arrested on February of 2020. Yes, but her case was brought in March of 2020. So it doesn't matter when she was arrested because they could have just been fact-finding and actually setting it for preliminary hearing. So, yeah. And it's surprising that they got moved that fast. So she was arrested in February because in February of 2020 is whenever I quit my job. And by March 23rd, we were in full, toilet paper panic. Well, the rest of the world was. I didn't really give 2 shits. I was working from home. So it didn't matter to me. The rest of the world was in full toilet paper panic. As a condition of Cashman's withdrawal, Cashman shall provide the court with an order and blah, blah, blah. Defendant Sarah Boone has forfeited her right there to court-appointed counsel Alternatively, defendant Sarah Boone has waived by her conduct her right to court-appointed counsel. The trial management conference shall remain specifically set for Tuesday, September 24th, 2024 at 1:30 p.m. Go pounded the debt. Simple as that. And this case shall remain specially set for trial for a week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause. Extraordinarily good cause shall not include retention of counsel by their defendant. Any and all pretrial motions in the case must be filed no later than the close of business Monday, July 22nd, 2024. So she's coming up on that there date, but I guarantee she'll file something. Why can she not? And of course, they send everything out to everybody. And that's what they were talking about right there. I think I went over this last week, but it was just well worth showing because we didn't have Laura's letter at that point in time because that gets filed as it would have appeared at that period of time. Yes, bitch, be crazy. And this is how the court system works. If you're wondering, I get this a lot only because, I am a legal assistant. So I get quite a few of these calls of why isn't anything happened on my case? It's just like, well, we're waiting on the judge to sign whatever order. I've even had them say, well, I'll just call up the judge and have him sign it. Yeah, that would be a bad idea. That'll get you in trouble with the judge. They don't like that. But I know people there. I mean, I can't stop you from being stupid, but that's not gonna get your case moved forward any faster. It might end up getting a judgment against you and possibly sanctions that you're reaching out to the judge without your attorney's, approval or consent. Because they'll be asking us, did you give your client approval to contact me? Absolutely not, Your Honor. Man. Oh, these people are so stupid. Oh my God. I cannot believe that there is, you've still got the Laura Owens stuff going on. She just cannot let go. She's like a rabid little chihuahua, just nipping at your heels, biting your balls, hurting every which way. Every which way, just causing problems. Don't know what to tell her. Don't know what to tell her other than get a grip. Get a grip, child. Get a grip. Laura Owens, Sarah Boone. Why is it that we have women that are doing the most horrible, ignorant crap? I'm not saying that women are horrible and ignorant. I'm saying these women in particular are horrible and ignorant. They're making their lives much worse. There we go. All right. Because I cannot help it. Cannot lie. I've got something good for you guys. Give me just a second and I'll pull it up because it's quite damn funny. And I think you'll enjoy it. If you don't, well, that is your problem because I will enjoy it immensely. She was arrested in February 2022. Present. Here we go. Share the screen. Oh, buddy, this is going to be good. Hope you're ready for it. Thank you, Old Squishy's Garden. You make me happy.
She is in jail. All right. 2021 CR 19158 State versus Matthew Aldridge.
Oh, yeah. Here we go. He's back. Another soft sit. It's always glorious. Judge Wolf is awesome.
I've been handed a document that states I, the attorney of fact, there is a ruling $25 I'm asking what form of exchange is acceptable. Also, is the trial going to be about trial by jury on the 15th of July? Only a bar member is able to respond by mail. Bill, Tennessee, United States of America, zip.
Well, my address, the address,
Pardon?
rather have the address private, with you, of course.
Microphone up so I can make sure I'm here. You have to speak up. We've run through this before. Are you, in fact, Matthew Aldridge, acting as your own attorney?
I'm in fact, I'm the attorney, in fact, for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Now, you understand Matthew Aldridge is required to be here today because his trial is next week. And if you are Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement.
Oh.
Otherwise, you're going to go to trial next Monday, is it?
The 15th?
You'll
The
be going to
15th.
trial, and it will be a jury trial.
Yes,
And
okay.
you're going to represent
I'd love to
yourself,
see
correct?
this one.
Correct. Yes, correct,
All right.
correct.
And we will show that you are to be here Monday. Raise your right hand, let's place you under oath. I just want to ask you a few questions on the record.
Well, and and here's the thing, Beth G, and I've said this before. It's not just about the women. Men also. Men that act fools make women look at all men as being that what is it? Chauvinistic, asshole, whatever kind of attitude. And they give the good guys a bad reputation. Of course, I do know that most women do tend to like the bad. Just saying. Don't know what it is. They like the troublemaker. I guess it's that a little more wild and bad. I don't know. I mean, I am a bit of a troublemaker. I only play nice on the YouTube.
Raise your right hand, let's place you under oath.
Yeah, fine.
All right. How old are you?
I'll be 40 this August.
40. All right. And how far did you go in school?
I graduated.
All right. From high school?
Yes,
All right.
high school.
Have you
graduate.
familiarized yourself with the rules of criminal procedure?
Yes, I have been.
All right.
Yes,
So you
I-
understand what the rules are regarding a trial. Do you also understand what the rules of evidence are regarding a trial?
Correct.
And you understand that you're going to be held to the same standard, acting as your own lawyer. You have every right to represent yourself. And I'm not saying you don't. I'm just simply saying you will be held to the same standard
As a
that
bar member.
any other defendant will be represented by an attorney. Do you understand that? You have an absolute right under our Constitution to have an attorney to represent you. And if you could not afford one, I could appoint one for you. But you have elected, if I understand correctly, to represent yourself and waive your right to an attorney. Is that correct?
Correct.
All right.
Oh, and this is exactly what Sarah Boone did. By her actions, this is where the judge put herself in this position where she is now representing herself. Oh boy, it's going to get wild.
Then we will see you. I'm going to ask that you sign this written waiver. Sign right there where the exit, pardon me.
Oh boy. He's about to get hurt. And see, it's on tape. Him signing this. He's not going to be able to get out of it.
Right, you can sign this without prejudice. Is that your name?
Without prejudice?
Yeah, without prejudice, your name?
3-301. Would you like,
Now, understand,
Uh,
we're not going to mess around when we come back next week for this trial.
I'm
not
aware
gonna
of
put
that.
up with any kind of foolishness where you don't identify yourself. Matthew Aldridge is the defendant. I know you are Matthew Aldridge. You're going to go to trial next week. And you're going to have to be in front of a jury of 12 citizens. We're going to pick a jury. We're going to try this case. And if you are found guilty, then
it'll
you'll
go on to
a
appeals
sentencing hearing.
court and
And then you'll have a right to an appeal.
Yeah.
But if you come in here and say that you are the attorney of fact, or that you are without prejudice, or whatever the situation is, you understand that I'm not going to put up with that kind of foolishness in front of a jury. You're going to have to represent yourself, but you're going to have to come in here and adhere to the rules. Do you understand that?
correct.
And that is the ruling
I don't
of the
think he
court. I'm going to show
understands.
that he has signed this without prejudice.
So you have a question. So if she represents herself and is found guilty, can she use that as part of an appeal? No. Nope, not at all. And that's the reason for all of those filings. So whenever a judge finds in this case and he starts citing case law and he's throwing those things down like that, the judge is saying, We're done with her shenanigans. She's playing a game, and she can bring it up in her appeal, but the way that an appeal works is you already lost. You already lost. Appeal is basically coming back and saying, did they follow the rules of the court? That's about the only way they're going to be able to find anything. Like if there was foul play of some sort, if they tampered with the jury, if they filed things improperly, or they misstated things that were proven to be wrong. Like you have to prove them to be wrong or incorrect. And then you have to make a case on your appeal, whether those things were done, whether the case law was done correctly, whether the case law was miscited, whether the dates were correct. I mean, it's like every T and I dotted and crossed. So that's you've got an uphill battle in trying to do an appeal. And someone like Steve Gosney would be able to tell you, by the way, you guys, free Steve Gosney.
But I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for a waiver of his right to counsel. We will see you on the 15th day of July. 9 o'clock.
9 o'clock. And this is how a judge should be acting. A judge should say, listen, we're not playing your game. You want to act a fool. You want to be stupid. You're thinking that you're something. Well, guess what? We're not going to play this. We are just going to make sure that we get this done. And we have another one. And these are short. That's the only reason that I'm showing them to you, because they are short little bits and pieces, and they're fun. They're fun, and it puts in perspective the silliness that people go through whenever they start doing this kind of crap.
All right, court is calling 2024 CR 42.
Oh, and by the way, thanks to old Squishy Gardner's Court Watch. He does this daily. He just pulls these things up. And Old Squishy's Gardner is where we find all of this stuff. If you haven't subscribed to Old Squishy's Gardner, please do so, because he could enjoy your support, and it gives him something to damn do besides garden.
260 and 2022 CR 4259W State of Texas versus Renee Angel Cantu. Can I have parties announced for the record for the state?
Well, and something to keep in mind, whenever they're stating part of the case nomenclature, and I pick up on it pretty quick, this case started in 2022. So this particular case started in 2022. Here we are 2 years later, and it's still not resolved. That's why whenever I hear people talking about, oh, wow, why wasn't I afforded a speedy trial? No, trust me. You have a right to a speedy trial, and if you have to file for that, and you have to push to have a speedy trial, which means that you may not be prepared coming into it, but a speedy trial means that we're just going to move on really damn fast.
Daniel, welcome to the state of Texas.
Defense?
Floyd Barrera, Jr.
All right, and are you Mr. Cantu?
One of your honor, yes, ma'am.
All right, you entered a plea on April 2nd of no contest in each of these cases. The court found there was sufficient evidence to find you guilty in each of the cause numbers. All right, and each of the cause numbers, according to the plea bargain agreement, the state is opposed to your application.
Oof.
And it states in here that this is running concurrent with CM 105821.
And I think, Judge, that's one.
And they're taking in consideration CM 104043, NIMAG number 712122 and 712121. All right, state, you are opposed?
Yes, sir.
All right, any witnesses from either side?
Just my client, Judge.
All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, your honor.
All right, you can lower your hand, state your name for the record.
Renee Cantu.
All right, defense, you
Good
may
morning.
proceed with direct examination.
Thank you, Judge. Good morning, Mr. Cantu. How old are you, sir?
I am 33 years old.
Okay. And
Excellent.
are you currently on
15-year-old.
probation in this court?
Yes, I am.
All right, and what are you on probation for?
I am on probation for a possession of manufactured delivered 4 to 200 grams that happened, I believe, in 2021.
Okay. Now, when you applied for probation in that case, which the court just ordered up, all of the matters that you've taken care of with Mr. Neil Cordero, they were all pending and included in the PSI that the court placed you on probation for. Is that correct?
Yes, sir, that's correct.
Okay.
All in 2021.
But since that time, most of those cases, the majority of those cases have been disposed of, either taking them into consideration or just outright dismissed.
Correct.
And now you're before the court on two of the cases that were pending before we even applied for probation in the case that you're on probation
Oh,
for.
yes.
Is that correct?
Yes, sir. That's correct.
Now, is it true and correct that since the court has placed you on probation, no violations of your probation have ever been filed or have occurred?
That's correct. Not one. And I've been on this monitor for 3 years. And since then,
All right.
and
So-
good.
You're on a monitor for 3 years, no violations of the monitor.
Correct.
You've been drug tested for 3 years and no violations of any drug testing.
That's impressive. Good.
Suffice it to say, 100% clean
Correct.
and in 100% compliance and in obedience with the court's probation.
Correct. And I don't know if the court remembers, but they gave me like a list of 9 things to do.
Correct.
Like intensive outpatient treatment, 12 weeks, a 90-day program, like just 9 separate things, but I've completed all of them.
Good
Yeah.
for him.
All right. And are you gainfully employed?
Yes, sir. I am.
Are you full-time employed?
I sure am.
And so suffice it to say that on page 2 of this PSI, the court was informed of this myriad of cases that occurred prior to you being placed on probation.
Oh, yes.
Okay.
Yeah, they knew it before, since the
And obviously, these cases are now disposed of, except for 2 that are before the court today.
Correct. Yes, sir.
Okay. So have any negative consequences occurred in your life since the court placed you on probation?
Not with
The court.
but with myself, of course. I'm like, so when I wrote the court a few times
He's a
ago,
talker.
I really didn't mean disrespect when I said, I'm not one of these hoodlum thumbs or thugs. I really did mean that. Like, I used to
Be a
mess up.
hoodlum.
Yes.
You used to be a hoodlum thug.
Yes,
That's
ma'am.
what you're saying.
So, like, I didn't mean it in a bad way, no offense, but I thought I was Billy Badass, excuse my language, but obviously that wasn't for me. So that's why I have done everything good now, because that life was stupid.
Okay,
Like,
so here's the thing. This is the point that the court wants everybody to get to. Number one, when he was placed on probation in this court for that drug case,
Oh,
the state
yeah.
was silent to his application. When I accepted that plea, I was not given any of the facts of this because these were unindicted cases.
Correct.
So I would like for us to get to the point as to the drug dealing, because when the stipulations that were entered into, that everybody agreed, these are the steps. He's selling drugs and he's moving a large quantity of drugs. That's why this is over, I think, 200 grams. And the case that he's on
Whoa.
probation for is not. The case that he's on probation for is, I think, 4,200.
correct.
And these are
4,200
over 200
grams?
grams.
Judge, when the offense that he's on probation for occurred, he was involved in drugs.
Holy cow.
They're all stated on page 2 of the old PSI.
Holy cow.
And
4,200 grams. Oh my God. That is a lot. That is a whole lot. So he had 9.29 pounds of drugs. That's 9 pounds and a quarter. Holy cow. Just imagine 9 pounds of cocaine, or 9 pounds of fentanyl, or 9 pounds of ketamine, or 9 pounds of weed. You know how much weed, 9 pounds of weed would be? That's a lot. We're talking about a couple of garbage bags, because not that I would know anything about this at all whatsoever, but weed is pretty light because it's basically just grass. Son. That's a lot. That's a lot of drugs.
Your Honor, all of that is history. And it is,
Yeah, it's history because you haven't been able to get your hands on any of it. Oh, geez, Louise, person.
obviously known to this court by virtue of the fact that since you have been in control of his life, placed him on a monitor 3 years ago, he has respected all the rules and regulations of the law and of this court. And so we cannot deny his history. It is there for you. It was for you clearly when you respectfully granted him his probation. Judge, he has made a 100% turnaround from the life that he was living.
Uh-huh.
That is not who he is today. And he has
That's how he
3 years
was. And
of
so he should be
sobriety to
charged
show
with it as
for
such.
his really a miraculous turnaround. Can I finish?
Yes, sir.
Thank you.
Oh yeah, tell him to
so-
shut up.
We respectfully submit that he has proven to this court in every way that he is sober, he is gainfully employed, he is making an honest living for maybe the first time.
Yeah, he noticed
And all
it
due
too.
to this
Yeah,
court's
it's like a teenager.
surveillance and this court's observations and this court's control. There is no reason to believe that he cannot successfully complete any term of probation that you would consider placing him on. To incarcerate him after he's made such a significant
Yeah.
change in his life, Judge. I mean, this is a success case. We don't have a lot of them in this world of ours, but he has proven himself in every single way imaginable to this court. So the purpose of the state being opposed to his probation, well, clearly, historically,
Oh.
I respect their position. But to oppose probation today, after the man has lived a law-abiding life, a peaceful life, and a hardworking, diligent life as far as being lawfully, gainfully employed, to throw all of that in the toilet and incarcerate him would serve what purpose? I mean, clearly punishment is punishment, but
Punishment.
probably God is the only person who knows how much he has punished himself over his young years. You know where his father is. His father's in the penitentiary for dealing drugs. You know from the last hearing, when we asked you for probation, this man has grown up in CPS world, going from home to home to home to home.
Oh,
Not a mom,
what
not
was
a dad.
me?
Okay, I understand your arguments, but do you have any more questions for him?
Yes. Do you believe that going to the penitentiary after you changed your life would benefit you?
Not at all.
Do you believe that it would benefit anybody in this courtroom or anybody in the community because after 3 years of sobriety, now you're locked up? Would that help society?
No, that would
Yes. I don't know.
be kind of dumb.
Well, are you a contributing member to this community today?
Oh, yes. For the past 2 years, yes. No, I pay tax. I do everything legally now.
Oh.
Can I say no?
Oh, you do your drugs
So,
legally?
yes, I just want you to hear for my own knowledge.
That's fine. There's no question.
All right, so I tell you what, counsel, you finish your questions, then I'll allow state
Thank you,
to
Judge.
do cross-examination, and then if
Okay.
there's anything you wish to address with the court, you can. State, it's your cross.
Judge, sir, just looking very quickly at this PSI. For one, did you review it with your attorney?
Yes.
Okay. Well, we're aware that during one portion it says the defendant denied suffering any abuse as a child and reported CPS was not involved in his childhood.
No, I was in CPS for from 9 to about 17 years old.
So why would it be in the PSI that your attorney didn't object to that CPS wasn't involved? And this is all stuff that they're getting directly from you.
I was in Child Protective Services from St. PJ's, from St. Jude's, like name on Low Ridge.
Okay. So just going back, also looking at your criminal history, you agree with me, you have quite an extensive criminal history.
Yes, sir, I do agree with you.
And being out of Denver, it would be a assault to drugging victim where you did get probation. You were given 4 years probation, and that probation was revoked.
That was like a lesser charge. It was a regular fight, except to like a plea. Like the plea that I had, it had to be something about drugging.
You have that in your.
Oh yes, when I was 19 years old, I'm 33 now. I was a teenager.
And again, it was revoked on that back in 2020, correct? It says
Mm.
right here in the PSI.
The case happened in December 21st, 2014, I believe.
One
It happened when I was 19 years old.
other thing I wanted to ask or get into really quickly was, what's changed? What exactly has changed?
I grew up. I'm not kidding anymore. I was hurt. I was angry, and I know I can't blame anybody for my childhood. Like he's like, yeah, your mom's dead. Your dad's. Who cares? Like I'm an adult now. Get over it. You have stuff to do. You have to be an adult. Have a job. You have everything. Be a man.
At the time of this offense, the offense that you're here before the court, who was living with you at that home?
I was actually hopping around at that time.
You don't think the judge is buying what he's selling me now? Oh, I don't know. I mean, it sounds good, but I think the judge is still concerned, and as they should. Hey, Direxia, how's it going? Good to see you.
So I did need money. So I was trying any little way, to get money at that when that happened.
And again, this is after you've already been arrested for other cases and already had issues with drugs in the past. Is that correct?
No, I've never had a drug issue at all in my lifetime until these drug cases. Never in my life. So once again, that drugging victim is a regular fight out of Denver, Colorado when I was 19, except the plea had to be assault with drugging victim, but there's like no drugs involved at all. That was just like part of the plea.
Another person, state judge.
All right, any other questions?
That's all, Judge.
All right, I have a question.
Yes, Judge.
So everybody, when they come before me, they're always talking about me. My question is, What do you think was happening with the drugs you were selling?
What happened? Say it again. I'm
What do
sorry.
you think was happening with the drugs you were selling? Where do you think they were going?
Hurting lives.
And you continued.
Yes. Yes, ma'am.
And why were you selling drugs?
Because I needed money, and I believe I had a job working at a warehouse, and I went from making like $6,000 a week to maybe $300-400. So that was not. I was so used to like living with $3,000 or $4,000 for my rent, for everything. So I started like panicking. Like, oh, dude, I need money, you know. So that's when I thought I was really badass, and I wasn't.
Oh yeah. So walk me through this. So you are working.
Yes, ma'am.
So how do you reach out to somebody saying, hey, I want to sell some drugs for you?
So I was kind of in the ghetto, in the West Side, and it's not hard at all. Like you literally just go right there. Tell someone, hey, dude, you know, what do you want? You have everything there. So of course I initiated. I'm like, hey, I need some money. Like, what can I do? And then yeah, that's how it. Like, okay, you want to work? Well, here we go. And literally, like the second time, that's when the officers like, oh yeah, by the way, I'm an officer. Like shit.
All right. Any other questions?
No, no.
Any other witnesses?
Yeah, go on.
All right, court will hear argument.
Judge, the state's can argue here that I think you should at least get a 10-year minimum. These are a lot of drug cases that are all coming in very rapid succession. He also has very extensive criminal history. The state asked what's changed between now and then. And there really wasn't an answer that was given. There was no details as to what he's done, other than being on under court supervision.
Yep.
He knows if he has positive for drugs, that's something that can get him in trouble. If he does anything out of line or if it's another offense, that's something that's just going to make it worse for him. So again, it's something that we haven't really had any details of what exactly has changed. So the state would ask for 10 years in prison.
Judge, his entire criminal history was known to the state when this court placed him on probation. Nothing negative has occurred. Everything positive has occurred. This is a successful probationer. This is someone who has changed his life around. I don't understand the logic. What has changed? This man has changed. The man for you, Exhibit A, has changed. His entire criminal history is spelled out very clearly when the same state of Texas recommended probation, or at least
silent.
remain silent. And no objection at that time was offered by the state when this court granted him probation. Judge, this court, has helped him, as he said in here. Why do you want to be on probation? And he said, because it'll be my mentor. And you, whether you have agreed to or not, have been his mentor. You, whether you knew it or not, have
He's
had
doing a good
very
job.
positive impact
Doing a
on
good
this
job
man's
working
life.
the judge. Let's see if it works.
Judge,
See if it
I
works.
can't underestimate the strength of the statement. He has not stepped across the legal line in 3 years. How can we punish him today for what happened when he was 19 or 20 or 21 or whatever? And
I
these
think this is from 2022.
these cases were already pending when the court considered everything and placed him on probation. He has not disappointed you. He has not disappointed probation. He has not disappointed anyone. His employer loves him. He is a hard-working, sober, contributing member of this community. To throw his life away and give him 10 years in prison, Judge, I don't see what good would come out of that, because he has demonstrated that he not only can talk the talk before you today, he's walked it.
So what do you think, Chad? And I'll put up a poll here shortly. Does he spend the 10 years outside of the judge? Give me just a second. I'll poll up for you guys here shortly. Give me just a couple of seconds. Should he continue to spend his time in jail? Should he be allowed to roam free? So what we'll do is we'll put in a poll here. And jail or freedom? Well, that's all we'll do, is which is jail or freedom. And give me just a second. I'll have this in here, and we're going to put that in there. Jail. And it's a pretty simple poll. Jail or the freedom. And we're going to add one more option. Stay on probation. So there we go. What should it be? What say you, chat? What say you? Do you say that he's free to go? That he goes to jail? That he goes free? We'll Sarah Boone hit your anger button. In all honesty, your husband's family always said it wasn't intentional when they screwed up. Well, yes, I know exactly what you're talking about with Sarah Boone. There is people like Sarah Boone out there, and they just go, it wasn't my mistake. It wasn't bad. We're looking at this guy right now. Give a vote there, and we'll tally that thing up at the end of this. See where you guys stand.
Every step, Judge, he's walked with you, with your probation office. I mean, thank you. He's not who he was because of this court.
Still
And now,
immature.
at the last minute, to pull the rug out from under him and say that we need now to protect society from what you did back before I gave you probation, I don't see the logic in that. What purpose would be served to incarcerate a middle-aged man who admitted that he was a young, person who did not respect
I mean, he wasn't young because this is in 2022. So it was 2 years ago. He tells me he's in his 30s.
Yeah.
So doing young and dumb things is usually teenagers, not people who are in their late 20s. I mean, that
Yes, I
for
understand.
the
that.
court,
That's
that
right.
argument, I'm young and I'm dumb and I'm in my late 20s and I can't control my impulses. That's usually for teenagers.
Sure. And that statement was going to all of that history that was brought up by the state, in Denver, Colorado, and here and there and everywhere. That's where that statement was going. Judge, he admitted his guilt. He came before this court. These cases have been pending a long time, and he has never absconded from the jurisdiction of this court. He's never missed a court date or a court hearing. And, he has patiently waited for this day to arrive, and it has. And I just would ask the court to consider the good that this court has done in this man's life.
Oof.
And why, throw the baby out with the bathwater at this time, Judge. It's 10 years of probation.
He's in
done
his 30s,
so far,
yeah.
so good. You can still give
So
him
when
the
he
10
was
years the state
31,
wants
he
you
was
to give him
busted
today.
on drugs.
You can give it to him tomorrow,
Drug
next
charges.
week, next month, or next year.
All right. Thank you. Anything else from the state?
Judge, again, these three cases that you have for you, you didn't have this information whenever you decided to give them probation the last time. It's because they were still pending. They hadn't been indicted yet. There was no movement on them. Now that they have come forward, this is what we offered based off of the facts that are in these cases. Again, the court did not have these before. You have them now. You have the ability to take this into consideration. This isn't a teenager who's making bad decisions. This is a grown adult, it's a grown man. He made these choices and the consequences that flows from them.
All right. Thank you. All right. So Deputy Mejia, Deputy Laura, if you'll take him into custody and counsel, you need to be back here at 11 and the court will make its decision.
Thank you, Judge.
All right.
Thank you.
So what are you
I'm
thinking,
on,
guys?
Video conferencing with the state board of pardons and parole.
All right. So we're back on the record.
What are you thinking, chat? What are you thinking? Come on, what do we got going on here? What do we got? We got 50% of you guys want him in jail. Oh, that means what else do we have here? Oh, but we won't know. You guys just keep on putting those votes in. Keep on putting those votes in. We'll see where he ends up. Oof.
In 2024 CR 4259W and 2024 CR 4260W. State of Texas versus Renee Angel Cantu. Why are you banging on the walls in the back?
My ankle monitor was going off 5 separate times. Officer Mejia heard it. I was like bringing it on the door. So I didn't want to get in trouble. It would be my very first violation in like 3 years. But Miss Priscilla Valadez is my officer. If you could please tell her.
No,
You're in
that's
jail,
not
so
what we
you're
heard
gonna
in the back.
violate your tether
Yeah, I was-
That it
there.
wasn't related to your GPS. It was you banging on walls.
No, it was me shaking the door to get his attention. But yeah, I think my thing's dead now and I don't want to get in trouble.
Is there anything else?
Your Honor, he has probably never focused on doing what is right for as long a period of time as you've had him on probation as well as on your conditions of bond. It's amazing.
It's good enough right now.
Yes,
It just started to get.
okay. It's amazing the turnaround that he has done. It's working full time, out of the I guess the situation, the
Dude,
friends he was
spazzing.
keeping, all of that, Judge. But he'll be the first to tell you.
Yeah, he probably does have
that
mental
it was
disability.
you and this court, and it was your probation officers who have guided him and mentored him and advised him and counseled him all the way through. So I don't know that he could have done any of this without being under your watchful eye and that of probation. You generally have some kind of excuses about ankle monitors, and typically, at least in 3 years, you think that you have some, even though it was just an accident, some violation, however minuscule. But gosh, I don't know how more perfect that you could get than perfect as far as his behavior. and his record, and in view of the fact that, as you can see, he looks perfectly healthy. This is a life of no alcohol and no drugs, and just really getting a grip on the fact that he knows what prison's all about, Judge. He's been there. He knows what jail's all about. He's been
Well,
in there.
magic words.
And he knows what his father's gone through, and he's still
Say
there.
the magic
So
words.
I think he's really just made a world of improvement over his personal life. And you know, because of all that you've done, professionally speaking, all the people he could blame, all the excuses he could have, he's got them if he wanted to use them. And you've never, ever heard him tell you anything about his past. His past is very checkered, no question. But also, you know, the hand that he was dealt
He
was,
does look
not
like he's
straight
going
aces.
through some sort of withdrawal.
Made the best with.
Yeah, I would be
and is
nervous
climbing out
too.
of a deep hole.
You're looking at 10
And he wants to
years in
continue to climb that
prison
ladder all the way out
for
and stay out.
9
So
pounds of
I would
drugs.
hope that you would consider all the good that he's been able to accomplish and allow him the opportunity to continue doing.
God, 9 pounds of
what's right,
drugs, that
what's
is a
good,
party
what's
for the
healthy.
rest of your life, however short it
You know,
might
you can just
be.
look at him. He's living a healthy life. Well, it's true.
Yes.
All right, anything from the states? All right, so here's the thing. Mr. Garahan, I know you're not the one who worked out this agreement. And this is why the court likes for cases to move quickly enough so that everybody, no violation of due process will occur. Because many a times I will have people who come before me and cases have been transferred from other courts where somebody's on their 4th or 5th DWI. And they come to me and it's been transferred to my court.
The
And this
DWI
person
is
has
different.
been on ignition interlock for 4 years because I end up with an old case that's been transferred from another court. And then what ends up happening is people will argue to me, this person has been in rehab for 2 years. Everything is going well for them. You know, isn't punishment about rehabilitation? And that's true. Punishment is about rehabilitation, but it's also about punishment. He was placed on probation by this court in another case, 2022 CR 11790. And he was
2022.
placed on probation in that case because parties proceeded on it as a possession case. Let me check to make sure.
So 2 years
Yes,
earlier.
parties proceeded on it as a possession case, and the state was silent. And while these other 2 cases were pending, that's when the plea was entered into. The court did not receive information about these 2 cases because I'm assuming, and anybody can correct me if I'm wrong, labs were not in, so no one knew what the drugs were would be positive for, and no information was presented to the court in the sentencing for the 2022 CR 11790 case. The weight of these drugs, what these drugs were for, because again, nobody had information on that. And the laboratory reports were not in. So hopefully more money will be spent in improving how long it takes for drug testing to come back. So we won't have a situation that we have now. So now what I have before me is I have a situation where somebody is on probation. The court hasn't received any violations of probation because these cases were pending when he was placed on probation. So technically that is not a
Yes.
violation. And in these 2 cases, you're a drug dealer. That's it.
Yep.
And you are building your happiness off somebody else's misery because drugs destroy lives, and people who are drug dealers are doing it for a quick buck.
Correction, Your Honor, I do
No,
not.
do not interrupt me.
It's not.
Oh, yeah.
You were dealing drugs.
Yes, I was.
You were building your happiness off somebody else's misery. There are people who are out there for whatever reason. Maybe they're young, they don't know any better, and they start taking drugs, and the next thing you know, they can't kick them.
Yes, ma'am.
Then you have some people who are in their 30s, they start using drugs, and then they can't kick them.
Yes, ma'am.
But this is destroying people's lives, and this was drug dealing.
Yes, ma'am.
Why the federal government has not come to your doorstep, I don't know. This is state jurisdiction, so I'm just dealing with what I have before me here. Under normal circumstances, all things considered, if you just had these 2 cases and you're not on probation with the court, I'd send you to prison. But you're on probation. And so I have to deal with what I have here. So this is what the court is going to do. In each case, the court is finding you guilty. The court is sentencing you to 10 years in the prison. That will be suspended and probated for 10 years.
Oof.
These cases will run concurrently. Taking consideration CM 104043, NIGHTMAG number 712122 and 712121. You're going to remain on GPS until further notice.
Yes, ma'am.
So that's GPS until further notice. Probation. I'm going to want random field visits until further notice. And there's to be field visits no less than 2 months. No less than every 2 months. I'm going to order the MRT.
What do you hear?
MRT,
What is that, Judge?
moral recognition therapy.
Okay.
There's to be regular reporting by Zoom or in person. The UA hotline until further notice.
I agree with you.
And probation, the UA hotline, he needs to be tested at least once a month, and it's random. But if y'all want to test him more than that, you can test him more than that. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And based upon what you said your occupation
Looks like defendant dodged a major bullet today and in his initial sentencing when they didn't know the weights of the substances.
is, they need to know what you're on probation for. And they need to provide a letter to probation stating that you've informed them what you're on probation for. Do you understand?
Yes, ma'am. It's already in file. They have, I was 10 steps ahead. I already had it from my boss.
Yeah. All right. Then you need to turn it over to probation.
Yes, ma'am.
And probation, you need to call his employer to make sure that that's the employer. There's going to be 200 hours of community service restitution.
Ooh, 200.
Probation, is there anything else?
Not bad.
And state, do you know if there's any restitution for, I'm going to put restitution for drug testing. I think the DEA are the ones who did that. Let me double check. I think it would be the United States government, and we'll see who wants it as far as the funds. All right. And probation, is there anything else? Anything else? All right. And also, you're not, just 1 second. And also, you're not allowed to possess any scales. So you're going to have to figure out how else to weigh yourself.
Yes, ma'am.
I need to have a new monitor installed before removal.
So last December, I believe, I came to you, I'm like, you placed me on probation and said, hey, if you.
Okay, let me just stop you right there. So here's the thing, and we're off the record. You were 2 seconds from going to prison. And when people are 2 seconds from going to prison, you know what they end up telling me? And I tell you, your attorney can tell you this too. And because I'm sure he's had clients do it to him. You know what? I will do a lifetime probation. And then when you get the probation, then you start asking for extra. So you need to hold on to the thought that you were 2 seconds from going to prison for 10 years. All right.
Yes, ma'am.
And now you're on probation.
Yes, ma'am.
So you need to let that marinate.
Yes, ma'am.
Okay.
Yes, ma'am.
All right.
I like that word.
All right. Yes. All right. Thank you.
Hey, thank you, Your Honor.
You're welcome.
Ooh. So let's pull up the what you guys thought about that one there, and we will end the poll. What do we got? We've got stay on probation 50%, jail 37%, freedom 12% out of 8 of you wonderful people voted on this. Oh, shame on you. So yes, he stays on probation, and you guys got this one right on the money. You ruled the same way that the judge would. Most of the time when it comes to drugs, and jail does not work as much as probation. I am with you on that. But that's only if probation is tailored to make you get and stay clean. Get and stay clean. Stay clean, folks. Stay safe. Stay wonderful. And tune in tomorrow night because we're going to have probably a gaming stream. It'll be a little bit different. And I'm not sure if I'm going to do video games tomorrow. Just feeling the need to blow some stuff up, and whenever I say that, I mean like in a video game, not like in real world kind of blowing things up, because I'm not into that. But I do like to play video games, and in those video games, things happen to explode, and that's fun. So everybody, go over, say hello to the expert, say hello to the White Rabbit, show them your love. And I will see you guys in the morning. Just like right now, you're 2 months free from smoking. Awesome. That is wonderful. That is wonderful. Stay safe, everybody. Make sure you hit the like button on the way out. Make sure you hit the like button on the way in. And you know what the deal is. It's all just about having a little bit of fun. And geez Louise, stay clean, stay safe, and stay stoked.